Welcome, everybody. This is the COVID-19 What's on the Horizon webinar, and we're going to get started. We're just letting people get logged in before we get started so that they don't miss anything. During the webinar, again, and I know a lot of you have been on several of our webinars, if you have questions for our panelists, please ask them through the chat feature. They will be monitoring the chat feature, and as they go along with their presentation, when they get to a place where they can stop and answer questions, they will do so. So please use the chat feature. Okay. We're going to give them just a couple seconds more. And we're going to allow people to come in as they log on. So with that being said, welcome everyone to the COVID-19 What's on the Horizon webinar. I want to thank you all for joining us. And I'm Karin Mayfield. I'm the Executive Director of the chapter, of the CAI chapter. And many of you know me already from all of these things. And again, as we go along today with the webinar, if you will ask questions through the chat feature, the panelists will be monitoring it and they will answer your questions as they get to a stopping point. So with that being said, I'm going to turn it over to Kevin Edwards, and Kevin, you can get started.
Okay, thank you, Karin. Welcome everybody to today's topic, today's webinar concerning COVID-19. Unfortunately, we're still all dealing with this, and hopefully you'll get a little more information and valuable knowledge as far as how the associations and board members in particular are dealing with issues concerning COVID-19. Today, I've got two of my partners in the law firm that are going to assist in presenting the webinar. First is my partner, Steve Mezer, who works out of the Tampa and our Sarasota office. And last but certainly not least, my good friend and partner, David Muller, who works out of the Sarasota office and also in the Naples office. So welcome to both of you. And I guess we're going to start the discussion. Steve is going to start the discussion sort of as the moderator, and we're going to hopefully have a discussion concerning a lot of the key issues right now that the associations are dealing with the COVID pandemic. So Steve, why don't you start us off with some interesting issues?
Okay, thanks, Kevin. Good afternoon, everybody. Again, my name is Steve Mezer, and I am with the Becker firm in both Sarasota and Tampa. I've met some of you over the past few years, but probably not everybody. By way of introduction, I'm a past president of the Suncoast chapter, CAI, back when it was the largest one in the state, but that's history. All three of us are board certified condominium attorneys through the Florida Bar, and our practices are devoted solely to the representation of condominiums, homeowner associations, cooperatives. You won't see us on television going for those injured people or anything like that. All right, so we're preparing for today. The three of us got together a few times and we're talking, and we figured out, well, we'll divide this into areas, and we were going to assign each one of us a topic, and that way you'd hear from each of us separately. And as we talked about the separate topics, we realized that there's not always uniformity in the opinions. In other words, like Becker or any other law firm may not have a uniform, solid opinion as to each issue. So we debate them and we go back and forth and we say, well, let's come up with this. And quite often I would be the protagonist, and we'll just say, David down there is my more conservative leaning friend, and poor Kevin is stuck in the middle. Sometimes he's with me, sometimes he's with Kevin, or with David rather, and we're going back and forth. And I thought, that might make for a little more interesting presentation of the issues, so that you recognize that there isn't always a clear and simple answer to a question when we're dealing with COVID. A lot of the legal issues dealing with condominiums and homeowner associations, they're tried and true. We pretty much know where they're going. If we have experienced those things before, but COVID's new for all of us. And so there are a lot of different considerations. So we're going to bring those out. So you might see some differences as we discuss them. We broke it into 3 areas. The first one is the condominium itself. So gentlemen, let's talk about the condominium and the impact of COVID. In this area, for our listeners, we're looking at things like the impact on the owners, property issues, contractors, guests, amenities, maintenance. Anybody got comments?
Well, I think you need to start, Steve, with the position that the board has the obligation to maintain and repair and replace all of the common elements in the association. And that goes for condos and HOAs too, except in HOAs, we call them common areas. And the board has, with that responsibility, the board has to be sure that they are maintaining their amenities, the common areas, common elements, in a safe condition. So therein lies one of the issues, is that, you know, what can the board do, or what must the board do to stay safe and prevent the spread of the COVID-19 virus? Okay, do they need to shut everything down? Do they need to clean everything down all the time? You know, what is their ultimate responsibility in that respect?
So what are we telling clients? If you cannot afford to shut it down, what do you do? If you can't afford to clean it, what do you do?
Right. I mean, I think, you know, it's a little different now. Certainly, we've been dealing with these issues since early or the middle of March. And, you know, there's a lot more that we know now than we did in March. So I think that is helpful for boards because in the beginning, there was a lot of, I mean, and, you know, lawyers and board members, you know, we're not medical professionals. Okay, so we, you know, you shouldn't be looking towards your legal counsel to give you any type of medical information as to how this thing is spread and how and what to do to prevent the spread of this. Okay, so, you know, as I said, the board has to maintain the common areas in a safe condition. That's your obligation.
So
Okay,
David,
now,
can we just close it and preclude the owners from having access to the amenities because we can't afford to keep them safe?
Well, it's certainly an option. I think one of the keys to this discussion is knowing right from the get-go that obviously this is a 100-year event. Let's hope it's another 100 years before we have to deal with this. So it's a 100-year event. You know, the statutes and governing documents weren't drafted with these types of issues in mind. The government has issued various orders and obviously different parts of the state. Those have to be considered. Basically, you have to look at your community. You've got to look at the makeup of your community. You've got to look at your facilities. You know, do you have on-site employees that are constantly cleaning, you know, the common elements, or do you have an outside service that comes once a week or, you know, once a month? These are all factors that go into it. But, you know, returning back to your threshold question, can a condominium association board shut down amenities as a result of COVID-19? I think the answer is yes. Yes, they can shut those down. They need to make those decisions, obviously, at a board meeting. They need to take into consideration all sorts of different factors. And they also need to be prepared for incredible pushback from certain owners if they decide to do that. To give you an example, I won't use the condo name, but one of my condo clients, the 5-person board voted 3-2, with the president being the deciding vote to close the pool down. And the next morning, there were 10 owners picketing outside of the president's condo unit with signs basically saying, "Open the darn pool back up." You know, you can't make these things, you can't make these stories up. So,
yeah. And did they open the pool?
They did not. They kept it closed. Now, this was a vote that happened. I think this is also very important for this discussion. This webinar, if it were held in early April, is different than the one we're holding now in September, right? In March and April, we really, nobody knew what to do, right? We got all sorts of mixed messages about masks and things like that. So I think in March and April and May, there really was a solid argument for boards who wanted to take aggressive measures to say, we don't know what's going on. We're getting mixed signals. All we know is we've been told the elderly and person with health issues are the ones that should be most concerned. And we want to take certain steps to help protect them. So it's a little bit different now that we know, it appears that the masks are helping. It appears we know a lot more about the spread than we did back then.
Okay, so here I am, the unit owner, the loyal opposition. I want to use the weight room. I want to go into the pool. I want to go play cards and play pool and whatever the amenities are on that property. I'll give you a release. I'll give you a waiver. Will that work?
Yeah, in my opinion, probably won't work ultimately. There's no harm in it, however, but legally at the end of the day, is that going to be an enforceable document? Because there are what we call anti-waiver provisions in the Condominium Act, which basically says that the association can't waive any of their responsibilities insofar as keeping the common elements maintained in a safe condition, and their duty to maintain and repair and replace the common elements. They can't shift that responsibility via waiver and say to the unit owners or the homeowner, hey, use it at your own risk. We're not doing anything. If you get hurt using this or you get sick using this, it's not our fault. Okay, so there's an argument that ultimately would not be of any use at the end of the day to protect the association from liability. That said, there's another discussion that, that liability is probably going to be very difficult to prove. Steve, you could probably, as a litigator, discuss that in more detail.
Yeah, obviously the plaintiff has to prove causation, but you may have that person who he or she has been isolated in their unit, and the only other outside contact is they touched a table at the swimming pool or in the card room or the elevator button. And other than that, they have isolated in their unit. The other people who live in the unit have no COVID. And now they say it had to be there because I didn't step foot outside of the condominium since last March. And here I am. Proof obviously is a problem, but there are going to be situations where they can. And, to David's example with the 10 people in the swimming pool, if 6 out of the 10 came down with COVID, there might be enough circumstantial evidence to be able to say they got it at the swimming pool because that's the only common contact these 6 people had, and they all got ill at around the same time. So it is possible, particularly in a condominium type community or in a homeowner association, where you've got groupings of people and that you find the commonality. So I'd be careful of that. We did have a comment come through from somebody who said, yeah, follow CDC guidelines at your own risk. You going to post one of those, Kevin, and just put it at the swimming pool and say, here, follow CDC guidelines. Good luck.
Well, I mean, it can't hurt, I suppose. More is always, better if you put out signs and other types of materials to warn and educate your unit owners and homeowners as to what they should do when using the facilities, when entering upon the common elements or common areas. Obviously, to be cognizant of the CDC guidelines and all of the COVID-19 protocols that the either the Department of Health has promulgated or the CDC. So certainly, I mean, you could always, and it doesn't hurt to always make sure that your owners are aware of these things and that they should follow these recognized guidelines and protocols. But it's in my opinion, it's not going to do any good if you post a sign saying, hey, you're using it at your own risk, and we're absolved of any liability. That's not going to work.
Yeah, and Steve, you mentioned it's probably going to be very difficult to prove that I got COVID because I went in the condo or cooperative or HOA fitness facility. I think that's going to be difficult for anybody to prove. But the reality is I graduated law school 20 years ago in the state of Florida. There are now more than double the number of law schools today than there were when I graduated.
Mhm.
I know you guys are younger than me, so it's probably a little different for you guys, but there's a lot of lawyers out there. There's a lot of lawyers in need of work,
Mhm.
and they would be happy the way the American legal system is built. If they can find a client and file a lawsuit, they're just going to hope that there's potentially insurance coverage or a quick settlement, even if the case is going to be hard to prove, right? Having a difficult case to prove never stopped American personal injury attorneys in the history of our country, right? So the bottom line is you've got to be concerned about the risk. You have to be thinking about insurance coverage. You have to be thinking about things you can do to position yourself if you do get sued. And at the end of the day, when you have to choose a lawsuit to be involved in, would you rather be involved in a lawsuit where an owner sues the association saying, you prevented me from using the fitness center? Would you rather have that lawsuit, or would you rather have the lawsuit where two 80-plus-year-old residents in your condo contracted COVID and passed away, and the allegation is it was because the condo failed to take certain preventative steps, common sense preventative steps to keep them safe? I think everybody on the webinar knows which lawsuit everybody would prefer to be a part of.
Absolutely. And quickly, I just wanted to mention that there was a comment about, can we discuss how this applies to co-ops? This applies to co-ops the same way it applies to condos and HOAs. Okay, so we're even though there's some co-op people out in the audience, the co-op statute and the Condominium Act are almost identical, not quite, but they're very close. So when we talk about condos and HOAs, we are including the co-op people out there as well. So don't feel like you're left out.
And real briefly on that, yes, co-ops, if it's a condo style co-op, a high-rise building versus maybe a mobile home cooperative type situation. I mean, part of the analysis is how packed in is everybody, right? I mean, if you're a 100-lot single-family home HOA, it's, the analysis is a little bit different than if you're a 20-story condo with one elevator and one fitness center and one pool. I mean, it's based on what we've learned about how you transmit the COVID-19 virus, the setup of your community matters, but whether you're an HOA or condo or co-op isn't necessarily going to be a dispositive distinction, I should say.
Yeah, and that also brings us to the idea of the owners and contractors and regulations that you may want to impose. Obviously, it could be quite different if you're spread out in that HOA that you mentioned or condensed into the high-rise building. You want to comment on that, David?
Yeah, my phone here, it just went off, Steve. So I was putting my phone away.
Mine too, and I just...
Yeah, sorry, I got a little distracted. Hopefully it wasn't one of our webinar participants prank calling me during the middle of my webinar.
Right.
No, why don't we address something, and I just got a question on the chat feature about, we talk about insurance, what insurance is involved if an association is sued over these COVID-19 issues? What type of insurance are we talking about? We talk about D&O insurance, talking about general liability insurance, what are we talking about? And is there insurance available for these types of things? And what is the, what's the deal with typically whether or not the associations can get it or whether or not they have it presently for these types of claims?
David, you want to jump in there? That was actually going to be my question for you anyway.
Oh.
So.
Yeah, so I always encourage my clients to have a good relationship with their insurance agent. Your insurance agent, candidly, I'm always a little bit baffled at the number of my clients that don't even really know who their insurance agent is. Your insurance agent is one of the professionals that helps guide you. They are also on the front lines of this. They're the ones that I call them the keeper of the policies, and they're the ones that help you get these policies and find a good rate and everything. So they're seeing a lot of these things on a day-to-day basis that don't always show up in front of on the radar of the association attorney. So number one, talk to your agent, find out what the policies say. And candidly, when I've had those discussions with my clients' insurance agents, I've gotten some different answers on the question of whether there is coverage or not. We talked a little bit earlier about American personal injury attorneys. insurance companies that do business in America come in all different shapes and sizes as well. So it would not shock me if many insurance carriers took a very narrow perspective and said, oh, COVID, on page 37 of the policy, there's some exclusions. Sorry, you're on your own. Will that really fly? The question then begs, if they're just going to walk away and say the exception covers it, and we're not providing coverage, you may have the ability to sue your insurance carrier, depending what the facts are. But of course, you really want to avoid having to go down that road. So the answer is, we're getting different answers from insurance carriers on that. I'm curious, Steve, what type of perspective have you received on those issues?
Yeah, early on, and I'll go perhaps even as late as early as the end of January, early February, I was getting the notices from the insurance companies through their agents, and some directly from the carriers themselves. There is no coverage. There is no coverage. That's usually a red flag for me. People start saying, we have no liability, we have no liability. That usually means there is. And, as David was pointing out, there is a split. There are lawsuits, obviously, all over the country already on this issue, and they're not consistent. And some of that is because the policies are not consistent. Some of that is because the judges view it differently. I think it was probably back in March or April, we heard the president at one of the briefings go, well, there's going to be business interruption coverage for businesses. And he says, I've read those policies and there's clearly coverage. I don't know. And some associations may have business interruption coverage. And to your point about, your agent is your best friend in these things. Yeah, I get it. We're suspicious. They're trying to make a commission, or they're not telling us everything, or they work for the carrier. Well, they're also your agent, and you can press them on it and find out, is there available coverage? Is there something else we could buy that would cover us for a pandemic or some kind of a condition? I had a gentleman come down with Legionnaire's disease who passed away at a condominium. They denied the coverage. We ended up going into federal court, and now there's coverage. So just because they say no does not mean that there is no coverage. But to your general question that Kevin was presenting, generally it's going to be some kind of a general liability insurance that's going to kick in, but it could also be under the D&O depending on what the directors decided. If the directors took a position or took no position, they could find themselves sued. So I would look under each policy depending upon the facts and see where they go.
Right. On that point, Steve, I've had a couple of clients be sued based on COVID decisions, COVID restrictions they implemented. Restrictions they implemented where owners were ticked off about those restrictions, including a restriction that said we're not going to allow unit renovations this summer. And in each of those lawsuits, directors and officers liability carrier has provided coverage. Right. So, we are seeing that. That's helpful. I've yet to have a client say, well, my insurance carrier walked away, but it could happen.
It could.
Yeah. And also a lot of these policies generally and typically will exclude claims based on pollution or other types of contaminants. So whether or not that they're going to try to use that to get out of covering COVID-19, I guess we'll wait and see. But it wouldn't surprise me if they're trying to use those pollution and contaminant exclusions to say there's no coverage.
Exactly. So David mentioned, keeping contractors out of the buildings and perhaps then guests and other people out of the buildings. Are we still doing that? And is there a reason to do it now if the CDC guidelines don't require that?
Right. Well, I think everybody's very much looking forward to tonight's first NFL game and the NFL games this weekend. And if you look around at the league, I promise there's a compelling analogy.
I'm waiting.
Yeah, I know you're both shooting me this look like, what are you talking about? Look around the league at how the different stadiums are handling it. My understanding is tonight in Kansas City, there's going to be 18,000 spectators watching the game. But when Tom Brady begins his Buccaneer career, there's going to be 0 spectators. So even the NFL can't figure out, there's no uniform guideline for the NFL to use.
Right.
That's similar, to what we're dealing with here. It's not paint by numbers. And you know, even in the state of Florida, Miami's allowing spectators, but Tampa Bay is not. So at least for the first 2 weeks. Anyway, it really depends on your community. It depends on your level of risk, and all sorts of factors.
Well, let's talk about that issue. And it was more of a hot topic issue probably during the beginning stages of the pandemic than it is now, although I still have clients that ask me, you know, are we still in a state of emergency, number one? What can the board do, number two, in exercise of its emergency powers? And three, can we adopt rules that restrict owners from having guests, that restrict owners from having tenants, that restrict owners from having contractors come into their unit or onto the common elements? Because you know, boards have asked that question pretty routinely, whether they have the authority to try and prohibit these outsiders from coming onto the property.
Yeah, it's interesting because you'll see those outsiders, the contractors, come in various conditions. Some will be wearing the face shields, the masks, the gloves, the booties, the whole 9 yards, and others come in with no protective gear whatsoever to do basically the same functions. You know, they're delivering furniture, they're doing cable television, they're doing electric service, plumbing service, painting, you name it, and there's no continuity, and we never know who to expect or what to expect. So would it be better for us to have guidelines as to protective gear and keep out the contractors or the guests who are not appropriately masked and perhaps gloved, depending on what they're doing?
Yeah, you know, but what about, you know, let's talk about the board's authority. Can the board, and I know, David, you're dealing with this specifically, can the board implement rules that say, hey, no contractors, no construction during this whole COVID-19 thing?
Yeah, so the first part of that analysis is, what are the board's rulemaking authority from the condominium documents? You want to look at that. You know, some condominium documents give the board far-reaching rulemaking authority, including into the use of the units. And some condominium documents are focused exclusively on the common elements. Of course, contractors can't just Star Trek teleport into the unit, right? They have to traverse the common elements to get to the unit. So even if you have a board has limited scope in terms of their rulemaking authority, there's still an argument that you can make those rules. So number one, you look to the governing documents to see what there is there. Number two, you look to whatever the government is mandating. And in our area, you know, West Florida, with the exception of maybe, Steve, 1 or 2 times in some of the counties you do work for within, the government basically stayed out of this, right? And there was a lot of confusion about, you know, well, Governor DeSantis and Tallahassee identified swimming as an essential activity. So that means that condo pools have to stay open, right? I heard that argument about 10 times. For the most part, the government stayed out of this. So the government's not really there to bail you out on this issue. You've got your condominium documents, and then of course you've got Florida statutes. Within the Homeowners Association Act, the Cooperative Act, and the Condominium Act, there are the emergency powers. Now, the big challenge with emergency powers is the language was clearly written with a hurricane in mind, was not written with a pandemic in mind. So there has been some debate about whether emergency powers are even in play, because there is a subsection of the emergency powers statute that talks about the ability of the board to do certain things in terms of keeping people away from and shutting down portions of the common area, common elements. So Steve, you want to take a crack at giving the good folks out there a Reader's Digest summary of what Tallahassee is saying about whether emergency powers does or does not apply?
Yeah, thanks, David. By the way, that was our third topic. Thanks, guys, for just moving right to it. That's all right.
That's what happens when we're discussing things, right?
I know, it's true, and that's fine, perfectly fine. On the emergency powers, you know, David's obviously right. It was designed for something else. It was not designed for a pandemic. So we're kind of stuck in no man's land, so to speak. The Department of Business and Professional Regulation actually took it and ran with it and said, not only does it apply to condominiums and co-ops, it also applies to homeowner associations. that decree was cited by a lot of people for a lot of purposes. So it kind of overlooked the entire gap between damage to property and potential injury to persons, because it's written in the context of damage to property. But we're more concerned about the health and safety of people when we're dealing with the pandemic. So it was round peg, square hole situation. The legislature has asked that the Florida Bar provide a patch, a fix to that statute, and one of our partners did the drafting on that particular patch, and it should come up in the legislative session this year, and it will address the issue of a pandemic specifically as part of the implementing features for emergency powers. To that end, some of our clients have adopted amendments to their rules or to their bylaws dealing with pandemic issues. And so it's become a lot more localized and a lot more specific to the property. Again, David brought up the scope of authority for rulemaking. That's really where, a lot of this comes from. So be careful with that. If your rulemaking says, the common areas and doesn't address the buildings, the homes, anything else other than the common areas, you may need to expand your rulemaking authority so that you have better control of those in the rules, because right now, at least through probably June of next year, it's really unclear whether the emergency powers statutes as they exist today give us authority. David, you look like you're ready to say something.
You're doing a great job summarizing a complex area of law, Steve.
Thanks, I'll keep going then. Yeah, and then you talked about the declarations of emergency, and yes, the governor has extended the declarations, the emergency orders for the entire state, which implements that particular statute to the extent it's effective. Okay, great. And as you also indicated, there are a wide variety of local ordinances, and some of them change week to week. And you'd have to be mindful of those particular ordinances, everything from curfews to restrictions on masks. You go into Sarasota, it's a mask city. Other cities just down the road, literally, are not mask cities. And you step out of your car and you got to wonder, where am I? Put the mask on? Oh, I'm going to put it on anyway. That's up to you. So right now it is literally a state of confusion. Kevin, you want to contribute?
Well, that is so true. It is definitely a state of confusion concerning this. But when we talk about, and you touched upon it about the emergency powers in the statute, does that in fact give the boards the authority to promulgate these types of rules? Let's say, even if you don't, as David mentioned, have the authority and have the ability to adopt rules concerning the units, okay, or the lots in a homeowners association, right? I mean, does the emergency powers section of the statute, arguably, does that get them there? Does that get you, well, we're in a state of an emergency, certainly, there's a pandemic, we should have the right to adopt rules for the general health, safety, and welfare of our owners, and therefore, we have this authority even without having to, rely upon the emergency power section of the statute, or can we rely on the specific emergency powers in the statute to adopt these types of rules or resolutions that will govern a unit owner's use or an owner's use of their unit or home or lot? So I know, and there was some debate whether or not, as part of those emergency powers, and they generally speak about the authority of the board being able to, close certain sections of the common elements or common areas when it's deemed to be unsafe, and to dispense with the normal notice requirements for board meetings and what have you. But the emergency powers really don't get into the authority to adopt rules specifically, because, for example, when the board in an HOA and in a condo adopts rules concerning unit use or home or lot use, the requirement in the statute is that they have to post notice 14 days in advance. Okay, so that doesn't appear in the emergency power section of the statute that it doesn't say we can dispense with that notice requirement, for example, for rules that govern the use of units or lots. You know, I mean, we would think that a court would interpret it that, you know, yes, of course, we're in a state of emergency, so the 14-day notice requirement should be dispensed, but it's not entirely clear in that respect. So, you know, nevertheless, I can tell you that I've had associations that have, during this whole period of time, routinely adopt those types of rules on the basis that they will generally have that authority to protect the health, safety, and welfare. You know, that argument that would override anything else.
Right, there's a provision in the emergency powers statute that talks about provide notice as reasonable, right? So that's something that I think is very important for folks out there. If you have adopted COVID-19 restrictions and they're still in place, if today, you know, in the middle of September, you're still relying on COVID-19 restrictions that were adopted with 24 hours notice at an April 10th board meeting, right? You know, I would encourage you to put it on the agenda, have another properly noticed board meeting and ratify that decision. And another thing I'm seeing a lot of associations are adopting these restrictions when the boards are just emailing each other on what they should do and never actually had a board meeting to begin with, right? So there's no board meeting, there's no minutes, there's no nothing. That's very problematic, obviously, if you get sued, because guess what? One of the allegations is going to be in a lawsuit, they're going to say the board failed to properly notice this. They adopted this in a closed room somewhere or via email. It's procedurally deficient, right? There's going to be procedural arguments and there's going to be substantive arguments. So those are some things to think about. But, you know, this pandemic has been around, at least in Florida, primarily for about 6 months. I know we all probably saw the news yesterday where, you know, one of the vaccines has a bit of a hiccup. They're still trying to figure it out. I mean, I think what's really important now that we're here in September, particularly many areas of the west coast of Florida are highly seasonal, and people are going to start showing back up November, December, and they're going to be here for several months. So I think we all need to be thinking about, you know, it may be not as a big crisis now if you've got 9 people actually residing in a 100-unit condo in the middle of September, but what's going to happen in early November when, you know, you've got 80% occupancy? I mean, these are the things that boards need to get out in front of right now.
Yeah, Kevin did a good job of listing out some of the things that do come up in the emergency powers statute, but one of the things that does not come up in there, in addition to the ones that he mentioned, was the right to borrow from reserves or use reserves for a different purpose, so do be careful of that. Now, guys, both of you hit on this health, safety, welfare thing. You know that's one of my issues. So, and just for the folks listening in, I'm really opposed to extending liability. You know, David has invoked the personal injury specter of personal injury attorneys coming to get us, and I don't think that's necessarily an irrational fear that they will try to sue you. So why are we setting up people to say, we're responsible for health of our residents, the safety of our residents, and the welfare of our residents? Anybody want to explain that?
Right. So this is an important distinction because I agree with you. We do not want to affirmatively take on extra duties that you know, are not our responsibility. That's on one end of the spectrum. On the other end of the spectrum, we don't want to turn a blind eye and just say, we don't really care what happens. It's going to be business as usual. We're just going to ignore everything and you know, leave it, leave everything the way it was before the pandemic. That's the other end of the spectrum. So this is why it's very important when you are adopting these types of restrictions or responding or putting things out, you know, newsletters, minutes, things on your website, be very careful with the words you use, right? Because as Steve mentioned, if you say, you know, in order to keep our residents safe, well, you've just decided to take on an added duty of protecting folks. And guess what? Nowhere in the Condominium Act, as you know, I'm sure this is, Steve's going to smile when I say this, nowhere in the Condominium Act does it say a condominium association's responsibility is to fully ensure the protection and health, safety, and welfare of its members,
Right, and they're not. Your board members are not an insurer or guarantor of anybody's individual health, safety, and welfare. However, once the board becomes aware of a potential risk or a risk or actual risk, whether that means something's in disrepair, whether that means there's a dangerous condition somewhere on the property, whether that means there's a virus floating around out there, that may then trigger an obligation to do at least something insofar as, warning the residents or warning your unit owners of certain issues, which I know, which is we're going to discuss, in that respect, warning residents, what happens when you become aware when somebody tests positive in the COVID-19 world, what do you do?
That brings us right to our third issue, which will be the association itself. And Kevin, you started with the known resident exposed to COVID, somebody who is self-quarantining, somebody who has a diagnosis, positive test for COVID. What are you telling people to do? And what's the liability? Is that a safety issue, a health issue, or none of the above?
Yeah, it's and there, as Steve mentioned, there is some debate over this issue. There's not one clear answer to it. But I've taken the approach with clients that I've taken more of a conservative approach. I probably will kind of favor David in that respect.
Oh, no.
But my position is I do not advise clients to disclose the name or address of any unit owner or homeowner that they become aware has tested positive for COVID-19. Now it's different if the unit owner or homeowner says, I don't care, you can disclose my name, you can disclose my address, and then, get that in writing and have your legal counsel look at that type of document before you disclose that information. But generally, I err on the side of not, or caution and not disclosing the person's identity or where they live, because now we do disclose that there is a case out there, there is an owner out there, and we let all the other unit owners and homeowners know, but we just don't disclose where they are or who they are. So, that's my position. And, insofar as liability for doing it, as we discussed privately, the other day, there is no HIPAA violation as far as the association is concerned. However, that could change if there's an employee
That's correct.
situation, and we talked about that. But that's how I handle it. And I know, Steve, you take more of an aggressive approach.
Yeah.
And
Because I'm concerned about those, personal injury attorneys out there that David is telling us all about. If I know that there is a hazard someplace in the property, again, we're using condominium as the example, but it's going to apply to, HOAs and co-ops as well. I know there is a hazard. There's a hole in the ground. There's a loose something or other. There's an electric wire. There's the infamous broken bottle. And I'm going to say, okay, folks, let's just be aware there's a broken bottle someplace in the condominium or out on the HOA property. Good luck. Watch your step. If I know exactly where it is, I better tell them. So if I've got that person with a positive diagnosis of COVID and they're in Tower 1 on the 10th floor, I can tell the folks at least that much. And if Mr. Smith came to me and said, I'm positive for COVID, he's entrusted me with that information. He didn't tell me that for my benefit as a board member or as a manager. He told me that because I am to him or her the condominium association. And I think we have a fiduciary obligation to the owners to disclose what we know and not tell them just this generic, gee, there's somebody in the community. Sure, if we've got 19 homes on the street, we all can speculate as to who it is and not be too concerned. But in a larger community where, everyone is suspect, I really don't think that hiding that information is in anyone's best interest. Gentlemen, beat me up.
Right. So yeah, I don't take that position. I do understand the background of and the support for the opinion Steve just gave. I get it, right? Because typically we know, for example, when an owner requests a service animal or something and submits documentation, I mean, we understand that that is clear cut. Not only is it clearly addressed in the community association statutes, there's medical records, things like that. It's not the same issue here. So I totally get that part of it. The flip side of it is I really am concerned about the association of the manager giving out someone's health information. And I also do believe when this issue has come up matters. For example, I represented a condo where the first reported COVID-19 infection in that specific county was a unit owner in this condo, right? And so the manager blasted an email saying, one of our owners has tested positive, right? And this was early March, and 2 owners were literally banging on the manager's door, demanding to know who the person was that was infected. And of course, the manager did what every good manager does. They called their condo lawyer to have the discussion. And ultimately, that manager did not disclose the name. This was actually a 5-tower condo association. Right. So the owners were not only demanding to know the name, they said, well, at a minimum, just tell us which of the 5 towers so I can avoid that one, right?
I agree.
Well, I told the client, I said, I still don't think you do that. I don't think you give the name away. But here's the reality. Every time I've been in that situation, it played out like it did in this situation. And that is the person who was infected, within 2 hours of those 2 owners banging on the manager's door, had contacted 10 of their neighbors, probably because of contact tracing and recommendations maybe from the government about reaching out to people you've been in touch with. And within 2 hours, it was the worst kept secret in the entire community, right? So it didn't really become an issue because anybody who really wanted to know eventually knew without it coming from us, right? Which, from a legal perspective, hey, you know about something, you know about someone's medical history and information, and it didn't come from us, so be it. But I hear what you're saying, Steve, but I think you would agree with me that it is not a black and white issue. There are shades of gray throughout that particular issue that we're debating.
Now, where I don't have a problem disclosing the owner's name and address is where that owner is refusing to comply with the quarantine requirements and is refusing to comply with rules concerning social distancing and wearing, a face mask or other protective equipment, and they're engaging in reckless type of behavior on the condominium or homeowner association property, putting others at risk. Then in that case, I will tell clients, and I have told clients that, yeah, go for it. You let everybody know who this guy or this gal is so that they can take precautions to stay away from them. So that's where I make one exception.
Okay, moving to still in association issues, meetings. Here we are today, we're on Zoom, and a lot of the associations are having their meetings by Zoom. Are those going to give you heartburn as association attorneys?
Right. So I have many clients who have annual meetings coming up in October and November, and I've had this discussion with them about what to do for those meetings. I also had, as I'm sure everybody who was attending this webinar, particularly if you're a manager or a board member, I'm sure you either dealt with this personally or some folks who had to deal with it. I had situations where there was an annual meeting, early to mid-March, right after the COVID pandemic, call it pandemonium for lack of a better word, hit. And we dealt with that. Should it be Zoom only? Should we do a hybrid? What's the situation? So here's what I'm telling my clients. I'm telling my clients, number one, let's talk it over. Are you going to just do the old school method, right? The old school method, which is you show up in person, period. There's going to be no Zoom or telephone in option. Or do you want to allow for a hybrid approach where people can show up in person, practice social distancing, wear a mask, but people are also permitted to attend via Zoom or via telephone? Or do you want to be aggressive and have a Zoom only meeting without offering the ability of folks to attend in person? If you go with the aggressive approach of Zoom only, right, and there's an election or there's a voting on important issues, there's a chance somebody could challenge it, right? And I do think the analysis is different from a meeting that maybe was Zoom only on March 10th, 2020, as opposed to November 15th, 2020, right? Although we don't know what the world's going to be like in 2 months, I do think the analysis is a little bit different, because I think back in March, like we mentioned earlier in the webinar, as we all know, we lived through it. It was chaotic. There wasn't a whole lot of information. We know more information now. So it is to go Zoom only. It's a more aggressive approach. I'm having this discussion with my clients, and most of my clients right now are falling in the middle ground. They're going to offer the hybrid approach. They're going to adopt a board resolution that permits members to participate via video or via telephone. They're going to, in that board resolution, they're going to clarify what all the criteria are for attending via video conference or via telephone. But there is going to be an in-person component. But if people want to attend in person, they have to wear masks. They have to do practice social distancing.
Where's the authority for that board resolution?
Right. There is a provision in the Not-for-Profit Corporate Act, Chapter 617, that makes reference to participation remotely, and that's the place we are turning to for support. Hopefully, with these new statutes that Steve mentioned that are in the works, hopefully come July 1st, 2021, we'll have a bright, shiny new Condominium HOA Act and Cooperative Act statute to look to, but we've got to figure it out between now and July 1st, 2021, because no one's coming to our rescue during that time period. We're going to have to make these decisions based on where the law stands now.
Yeah, and that's the 617 provision applies to HOAs and co-ops too, so it's definitely something to be aware of. Kevin.
Yeah, I was just gonna say, 617, as David mentioned, certainly acknowledges the right or the option of having unit owners and homeowners attend meetings remotely. I guess the bottom line question would be, can the board or our board of directors, are they authorized to require and mandate that membership meetings, including your annual meeting during COVID, is going to be held exclusively by Zoom or other remote means? That's the bottom line, whether they can do that.
Right, no, exactly. I mean, there are arguments to support that position. And Steve, you want to go over what those arguments are?
Yeah.
That's why I raised the issue. Steve has a good argument.
Okay.
Steve's a very compelling litigator, has some crafty arguments, and we're happy to hear him.
Thanks, guys. What I was confronted with was these gentlemen were saying that you had to have that perhaps hybrid where there was a place. And I think that goes back, and I am a year or two older than David. But back in the good old days when you had a speakerphone for board members, because that's the only time you could do the telephonic participation, you always had to have a place, a location for the meeting. So you had the speakerphone set up in the clubhouse, manager's office, some unit, whatever it was. So there was a place for the meeting. Unit owners could go to that location so that they could hear and be heard. And now, many years later, here we are dealing with Zoom. And I point out to them that court proceedings, and we start with the United States Supreme Court, oral arguments were heard in the last couple of months via Zoom. And the judges were anywhere from home to their offices and any place in between, as were the attorneys making the argument. And it was considered law of the land based on that. And they were all in the presence of the court. And if we go down to local courts, all of your circuit court hearings, county court hearings, mediations, they're all done by Zoom. It's really, it's today, it's the current standards. And I think it's kind of, you're not going to get very far in a challenge to say, well, the cooperative, the homeowner association, the condominium has a higher standard for being present than the United States Supreme Court. So here we are. And if we go back, and it's now since like 1980, Florida has been using video appearance for jail hearings, where you're brought before the judge within 72 hours of your arrest. You appear before that judge by television. You're not anywhere near the courthouse. You're, in some instances, 20 miles away from that judge, but you're deemed to be in the presence of the court for purposes of the Constitution. So if it's good enough for the Constitution, I think it's good enough for the cooperative. It's good enough for the condominium, and it's good enough for the HOA, because the features are that you can see each other, you can hear each other, you can be heard, we can show each other documentation. I can show you my yellow pad and so forth. It has all of the features and all of the things needed to have a meeting. And if I need people to, take a picture of a ballot by phone and send it to me by text or email at a given address, we can do that. So I can take my balloting at that meeting, condo, HOA, or co-op, or I can do something a little more sophisticated and get into electronic voting and never really have to do David's hybrid where I've got to figure out a location, because candidly, I've seen that happen, twice in the last few months, and neither time did they pull it off well. There was always an owner or 3 or 4 who came without a mask, who got in someone else's face, who later tested positive. I had a president of a condo association who was not wearing a mask, tested positive after the meeting because they were doing the hybrid. So I'm really urging my clients to stay away from the hybrid because it's not gone well for them, and I just don't see the need for it.
Also, too, remember, other factors matter. For example, if the place where the condo, the HOA, the cooperative, if the location where they almost always meet for their meetings is no longer permitting the use of the facility. For example, we do seminars, or back in the old days when we did seminars in person,
Right.
the good old days, there were churches up and down the west coast of Florida that we had good relationships with where we would hold our seminars, right? I think every single one of them has sent me a letter saying, hey, Dave, I know that for the past 8 years, for the past 13 years, in February, you've done this seminar at our church and you've got a great relationship. Please note that we're not allowing those seminars to go forward anymore, and we probably will not change our policy back. So where's the Becker and Polyakov seminar going to be? Well, it's probably going to be via Zoom, but with community association, same issue. If you can't find a place to have your meeting, how can you do the hybrid approach,
Sure.
right? And that just feeds into Steve's argument. If you can't find a location, then what are you supposed to do? Seems like a Zoom meeting is a reasonable alternative.
Kevin, you want to talk about electronic voting?
Well, electronic voting, as I tell my clients all the time, electronic voting is certainly different than email notice. Okay, sometimes you get that confused. But electronic voting is becoming more popular nowadays, certainly since COVID. And essentially, electronic voting allows the unit owners and the homeowners to vote, electronically via email. They can sit at their computer and they can attend the membership meeting and vote right there from the privacy of their own home, no matter where they are. And that's email or electronic voting. So, during COVID, like I said, that is becoming way more popular. And in fact, I've had, and David and Steve probably have similar numbers, I've had over the past couple of months, or certainly since the COVID pandemic has started since March or April, I've had about 30, 40 clients sign up for electronic voting where they never even wondered about it in the past. But now, since the COVID has hit, they're saying, hey, this is a safer way. This is a way that owners can participate from the privacy of their own home, and we can still get them to vote on issues. So, that's how it relates to COVID. It's become more popular since COVID.
Yeah.
If you want to go ahead and do it, the board, certainly can authorize it, and the board would have to authorize if the board wants to be able to take advantage of email or electronic voting. The board has to authorize it via resolution, and then they have to send out consent forms to all of your owners or home and unit owners so they can disclose their email address and the consent to vote via that way. But that's, as I said, that's if clients want to do that, associations are interested in doing that, it is becoming more popular in light of COVID.
Yeah, absolutely. It also increases participation. did see a question, or at least maybe even a comment. Somebody was mentioning that they were asking actually about the manager being, present by Zoom. And I'm finding a lot of them are doing that. And it could be for a variety of reasons, not the least of which could be that they may be more susceptible, whether they have a medical condition or an age issue, such that they don't want to put themselves in jeopardy to come to your meeting, to come to your property. So board members, please be tolerant of that and understanding. We had a discussion this morning with somebody who wanted a personal appearance and all that, and say, well, you really can't compel somebody to put themselves in harm's way. Last small topic, Karen, will be the impact on budgets and assessments and the foreseeability of increased expenses. Maybe we have more cleaning expenses. Maybe we have different payroll issues coming up, and we may see a fall off in some assessment revenues. Gentlemen?
Right. So those are things to think about. Certainly we don't want a repeat of 2008, 2009, when the world ended for the first time. We certainly don't want to see that, but it could happen. So it's a good idea for boards to be very much tapped into their fiscal health of their association. Do you need to raise the budget? Do you want to have a line of credit? These types of things. All things to be thinking about to make sure you've got enough money to run your corporation and run your association. Kind of piggybacking a little bit on what Kevin said earlier, I found that 2020 has been obviously a disastrous year, right? But if you do try to focus on some of the positives, and these are steps I'm learning. I'm a recovering pessimist. So as part of my therapy, I am trying to focus on positives. One positive is
Good for you.
people are much more willing to embrace some of these concepts like Zoom and electronic voting. I mean, these are ideas where candidly, when I brought it up in 2018, 2019, a lot of folks would say, oh man, another password. I don't want that. Now, one of the silver linings of 2020, one of the few silver linings, I think your communities, regardless of the age of your community, people are understanding the importance of these steps and are really embracing the options. And I'm also finding that with electronic voting and having Zoom meetings and things like this, it's adding an extra cachet, if you will, to the community. Oh, wow, they do electronic voting. I mean, they're with it. It's a modern community. It's not the sleepy old little community it used to be. We're embracing modern times.
All
Well
right.
said.
Yes. Thank you, gentlemen. I think we're out of time. I see Karen popped up to give us some closing comments.
Some chat questions, but
Yeah, are there does anybody online have any questions for the panelists?
Sure.
Because we do need to wrap it up, but if you have a question, let's put it in chat now.
I see somebody asked, is the anti-waiver in 718?
yes. Yes, it is.
Mhm.
I don't have an exact quote for you, but I think it's somewhere in the beginning.
Okay.
Is that?
Yeah.
But we can provide that if they wanted to email any of us separately. I'll find the exact quote for them, or the exact statutory section.
And also in Florida Administrative Code, I believe.
Okay.
That's right.
Okay, state of emergency. We had a question on that. Yeah, it was just recently extended. It has now been extended through, I believe it's November 3rd. So we are still in a state of emergency in the state of Florida. And most of the counties that, most of the counties on the west coast of Florida, I don't have the exact county by county breakdown, but several of them, and I would predict most of them, if not all of them, have their own state of emergencies that have been extended.
What I did want to mention really quick, though, which is good advice for condominium association directors and managers, because they'll deal with this, is the concept of having a force majeure clause in contracts or in any type of agreement, where basically it says that due to an act of God or due to some unforeseen circumstance like a casualty or whatever, or in this case, a pandemic, a virus, an illness, we're becoming more specific in defining what that force majeure means, that if that renders performance unreasonable or impossible, then you don't have to pay, you don't have to perform during that period of time where, for example, there is COVID in place, where there's a state of emergency in place. So I've been telling board members to be cognizant of that when they're negotiating contracts to make sure that they're protected with a good force majeure clause in the contract.
Another a part of the state of emergency question was, does Zoom attendance count towards a quorum? I would say it does, doesn't it?
Yeah, I'm counting it.
Yeah.
Yes.
And then there's a
Right. It's
couple
good
of
idea to
Q&A
adopt a board resolution though beforehand to
That's
clarify.
right. Mhm.
Can you rely on a staff member to clean the clubhouse restroom, or do you need to hire a professional to clean?
Okay, as a former busboy from Cracker Barrel that was cleaning
Clean the
that,
restroom.
yeah, that was one of my first jobs. Yeah, I mean, I don't think it necessarily has to be a professional. You know, your staff folks can clean it, but I do think it's a good idea to have procedures in place, and just like we did at Cracker Barrel, have a sign-in sheet so it's clear when it was cleaned. You know, all that stuff can help you out when you get hit with one of these personal injury lawsuits that we've been talking so much about.
Oh, there you go again, because I'm on the more conservative side. I'm going to, unless I have a staff member who understands how to clean in compliance with CDC guidelines and, you know, proper protocol for doing these things, I'm going to trust the professional to do it because of the liability. If somebody misses a surface and somebody claims that that's the surface that got, you know, grandma ill and grandma dies, I really don't want to be in that lawsuit, David.
Right, but that's assuming that a condo or a community association is affording, you know, they can afford to have, you know, some licensed
That's the
professional
problem.
person come in. I mean, this is the rub. If we all had infinite budgets, you know, we could have the top people in the country come in hourly to make sure everything is sanitized, and we don't have
Absolutely.
that. So it's
But can you really prove where you got it?
Circumstantially.
We
And
discussed
that's
that.
Mhm.
I was going to say, we discussed that during part of the webinar here, but yeah, it's difficult, but Steve said circumstantially, you know, it's just by preponderance of the evidence, I guess.
Yeah, if the person who we know has COVID is on the 10th floor and I live on the 10th floor and I push the same elevator button or go to the same area in the mailroom, and all of a sudden there's this commonality, and that's the only exposure that I've had to the outside world, then I might have enough to at least get past what they call directed verdict to put it out to a jury.
All right, well, I think that you guys have answered all the questions. I want to thank you, Kevin, David, and Steve for doing the webinar. It was really informative, and I'm sure everybody enjoyed it. And just so you know, our next breakfast in October 7th at the Grove for our members, we are doing a electronic voting program. So we're kind of timely with y'all here.
sure.
So wonderful. Thank you. I
Thank you.
appreciate it so
Invitation.
much.
Thanks, everyone.
All right, thank you. Stay safe.
Take care and
Right.
stay safe.
Yep.